Protection District. We have two appellants. Who wants to go first? Mr. Briggs, why don't you go first?
Your Honor, I think Mr.
Yes, Your Honor. I would request to go first on behalf of the Julian Fire Company.
All right. Well, Mr. Sherman, you can go first then.
Thank you, Your Honor. Good morning, Your Honors. Craig Sherman, on behalf of the Julian Fire Company Association. This matter comes before you as an appeal from a dismissal of judgment on a motion for judgment on the pleadings. There's really two principal arguments and basis for the appeal. One being the exhaustion of administrative remedies, and second on the statute of limitations. I want to take the exhaustion of remedies issue first. I'll move on to the statute.
Counsel Justice Haller, from
Yes.
my perspective, it will be important for you to talk about the laches argument. I understand that the court did not find on that ground, that she found on two different grounds, but of course you're aware that we certainly have the right to look at that as well on a judgment on the pleadings. So I'll leave it at that.
Thank you, and I can briefly touch on the laches first. I'll move back to my argument if there's follow-up.
That'd be great. Thank you.
You're welcome. My pleasure. The laches issue is it's a question of unreasonable delay. The proceeding for the trial court was progressed based upon ancillary and pendant proceedings. One was before this court on the Southcott case, a matter that would have been dispositive, and sent the matter back on the basis of a referendum. As that was pending, and it teared up exactly almost when the first writ hearing was promptly scheduled to be heard, and on or about that time, that matter was taken off calendar because this opinion from this court was pending, and that was issued on or about February. So while that appeal was pending in a matter of months, that case was expedited, a ruling was obtained, it was adverse. Petitioners immediately went back to the Superior Court for adjudication. I don't believe that's just unreasonable delay. Secondarily,
Counsel, let me be more specific. There was a hearing set for your writ in this case, not the referendum case, but in this case, to be heard on November the 2nd. And on October 23, you took that matter off calendar. Shortly thereafter, within about 10 days, we have a change in the board, and the board says they are no longer opposed, that they are opposed to dissolution. We still have everything going on with respect to the election process, and between October and then we have several months that go by. Your writ on the Brown Act could have been heard, but absolutely nothing occurred until after the voters voted in the special election that they agreed with dissolution. And then it's at that point that your side goes into the court to say, please issue the writ of mandate. And oh, by the way, the association and the district are now aligned. So what I'm trying to focus on is from that time that you had a hearing, you took it off supposedly because and from the referendum, but never did anything to bring it back into the court's attention while an election is going forth with the public. So if you could concentrate on that time period, at least from my perspective, that would be helpful.
Yes, Your Honor. Well, there were two different elections. The litigation for the referendum before the Superior Court.
Yes, I'm aware of that. No,
right.
I'm talking about the election that was triggered because of the LAFCO actions.
Yeah, that election is a different election based on a different type of voting that the petitioners were not trying to obtain. Number one, it looks to people who own certain acres of land, and with the weighted voting, that was not the election for which petitioners were availing themselves of the court to have a proper election based upon the members of the district. So I see Your Honor's point in, while LAFCO's parallel proceeding was going forward with its dissolution type of voting, we viewed this case as being, the right to the decision of the district, which was controlling and affecting LAFCO jurisdiction, as two separate complete actions. I mean, the district had its own rights and remedies as its own legislative body, and petitioner was working through that process and not through the LAFCO process. Now, all the parties, including LAFCO, was aware of both proceedings. There had been discussions between counsel. There had been settlement discussions for which, LAFCO counsel was aware of the proceedings of in this action. So we don't see that as prejudicial to the extent all the parties knew exactly what was going on. The county and LAFCO were immensely aware of the Brown Act proceedings and our positions that, if you don't have a valid application, you cannot proceed. So from that awareness perspective, and this is not an immense amount of time. And then the last point on laches, and I'll move on, Your Honor, is that it doesn't apply where these public type of rights are at play. With an administrative law, with respect to the law, it is more of a applicable to private parties, and there's case law on the point. We didn't have the chance to brief it in as much as we did in the trial court, but not on appeal, that it doesn't apply as to agencies who are aware, and when the law is trying to be enforced, that they do follow the law in this Brown Act context.
Right. Thank you very much.
I'm going to be short on time, but I'll move just briefly through what I had thought the primary issues were, being the exhaustion and statute of limitations, with the statute of limitations being fairly strictly a statutory construction question. We believe we're right on that because within the construct of the statute itself, the interpretation of the trial court, and we briefed it well if the court has any questions on it, if you were to not have the agency take an affirmative action, then you would obviate the other subdivisions of the code 54960.1, the subdivisions C3 and C4 would be obviated if you didn't have an affirmative act, which was a rescission and noticed, or affirmative act that we're not going to act to invoke the 15-day statute of limitations. Petitioner in this case filed on the 44th day, which was within the default provision of subdivision C2. On the exhaustion question, we believe that's answered fairly clearly. There was a notice given. The notice appraised the district of the demands for retraction and rescission. Council wrote back, paraphrasing and understanding what was being requested in that notice, and the district ultimately did not come back and rescind or follow the code with regards to the rescission. Argument in the trial court is, well, they didn't write a further objection letter when they continued to proceed with the action. And the main crux of the argument is, we had properly noticed, you were aware of it. When you came back and you should have rescinded, what did you do? The district adopted its further on action to set the terms of conditions for dissolution. It didn't rescind. It didn't follow the Brown Act as to what it's supposed to do with regards to decisions. It's cited in the Boyle case, the Supreme Court references in the Roberts case, and really what needs to be done is you need to rescind. You need to reset. They didn't reset. They went forward with the dissolution proceedings. So those are the primary issues that petitioner raises on appeal, and I'd like to reserve a bit of time for rebuttal, please.
All right, very good. You have about 5 minutes left. Thank you. All right, Mr. Briggs. I think we lost.
Your Honor.
There you go.
Briggs, we're having trouble hearing you. It looks like your bandwidth is quite low.
Much of it.
Mrs. Huffman, perhaps we should ask Mr. Briggs to call in because it's showing that he has a poor network connection.
Mr. Briggs, why don't you pick up the telephone and call in on the number that they've given you? Your video is not working. Why don't you call in on the telephone, Mr. Briggs?
I'm doing so right now, Your Honor.
Thank you.
Perfect. Thank you.
Hello, this is Corey Briggs.
We can hear you.
Okay, may I proceed, Your Honor?
Justice Huffman, can you hear Mr. Briggs?
Well, speak up, Mr. Briggs.
Hello, Your Honor. Can you hear me now?
I can hear you now.
Yes.
Okay, I apologize. Let me basically start over with may it please the court. I think the briefs are thorough on the issues. I don't want to spend time on the propriety of request for judicial notice unless the panel has questions, which I'll be happy to answer. What I do want to focus on is the narrow issue that my client's appeal presents, and that is whether a public agency that cures an alleged Brown Act violation is entitled to have the lawsuit dismissed with prejudice, even with the lawsuit pending. We think those are straight cases of statutory interpretation where the statute is not ambiguous, which means the court simply has to apply the law as written. Under Government Code Section 54960.1a, there's nothing that prevents an agency from making a cure. And under subsection E of the same statute, when the legislative body of the agency makes the cure or correction, the action shall be dismissed with prejudice. That's mandatory. The subsection A doesn't require any sort of special compliance. Even if it did, there's a presumption of compliance, which has to be refuted by the party opposing it. So we think that the issues raised by the Volunteer Fire Association are actually moot because the lawsuit simply should have been dismissed with prejudice once my client submitted the resolutions showing that the cure had occurred. At that point, the trial court should not have reached the motion for judgment on the pleadings, even though they were scheduled for the same time, because the matter has to be dismissed with prejudice. If there are questions, I'm happy to entertain them, but that was what I wanted to emphasize, that the agency always has the right to cure a lawsuit at any time, and at that point, the lawsuit has to be dismissed. Thank you.
Are there any questions from the panel?
No.
Apparently not. Thank you, Mr. Briggs. You have time to respond. All right, well, let's hear
Thank you.
from the respondent, LAFCO.
Good morning, Holly Watley on behalf of San Diego LAFCO. I want, as always with the oral argument, you have your remarks prepared, but I want to focus in on what was of interest to the panel, and that is the latches argument. The district is claiming, of course, that it had the ability to cure and that the action should have been dismissed based on that cure. However, the trial court actually, in denying that motion to dismiss, although the court did not use the language latches, in fact, the last substantive paragraph supporting her ruling on denying the motion to dismiss goes through and cites, in fact, facts supporting the delay that the district engaged in. They did indeed have already scheduled a trial on the Brown Act action for November 2nd, and for whatever reason, they took that off. Their prior appeal on the referendum of the resolution of application demonstrates that the association knows how to go in ex parte to try to set something for hearing before agency action is taken. And they deliberately chose not to do that here. They waited until after LAFCO held the hearing on the application and granted it. That happened in September. They waited until after the protest hearing, which was in October, just before what would have been the November 2 trial date. They did not seek to get a decision before the protest hearing. They did not seek to get a decision before the county called the election, nor did they seek to get a decision while the election was pending. They waited until 2 weeks after the voters had confirmed the decision. And so while latches, the concepts of latches and estoppels normally are applied with some reservation against public agencies, case law is clear that you nevertheless may still apply them against a public agency if there has been significant detrimental reliance on that action, and that is what happened here. It's not just LAFCO's reliance. It is not just the county's reliance. It's the voters. It's the voters' reliance. So those factors supported the trial court's, among other reasons, trial court's denial of the dismissal. And so that, in fact, the district did not have the ability to cure without running afoul of latches. A couple of other points in response to the argument from the association. And just to be clear, the election that took place that was triggered by the protest proceedings was an election of registered voters in the district. The protest proceeding, which took place in October, which triggered the election, that, in fact, is one where it's based on the number of registered voters that protest, or also landowners based on a weighted acreage of their land within the district. But once that vote was triggered, it went to the registered voters, the very same election that they were looking for and wanted. And it was only when the outcome of that election was against them did they begin to sort of scramble and in fact actually collude together without alerting the trial court to that they wanted to have an unopposed trial, to have judgment entered against the district, which the district did not oppose, exposing itself to claims for hundreds of thousands in attorney's fees, and then within 24 hours or possibly less of obtaining that collusive judgment, engage in what they purported to call a cure. The trial court did have before it sufficient evidence. The district argues that the trial court should have granted their motion that they did not need to establish compliance with the Brown Act in relation to that cure. And they cite an evidence code 664 as a presumption. But that presumption is rebuttable, and the court had all the evidence before it needed to reasonably conclude that that was rebutted, and they needed to affirmatively show compliance with the Brown Act. That one point illustrates, really, it encapsulates sort of the I would call it a hall of mirrors that essentially is what appellants argue here. They're hoping to distract. They tried it with the trial court, and they're trying it here with a hall of mirrors, somehow claiming that, for example, the district back in February, March, and April of 2018, well, the court can't decide whether there was a cure then. But later, now when the district engages in actions, now the court does have the power to find a cure. As another example, on the cure and the letter asking for a cure back in March, somehow they're asking this court to say, even though that letter alleged a secret agreement to restrict a board member from participating in decisions, they somehow argue that that letter, dated March 9, alleging that secret agreement, applies as an adequate demand to cure actions that took place after that letter and then involved secret agreements other than what was alleged. I think the height of the hall of mirror issue is the district claiming that it has standing because it somehow is aggrieved by a judgment in its favor, finding no valid Brown Act claim, relieving it of any obligation for attorney's fees, that somehow a ruling in its favor, they are aggrieved by it, and they can come to this court. They would presumably be happier with a judgment against them, exposing them to fees. Collectively, the arguments are essentially a heads I win, tails you lose. And the trial court didn't get lost in that hall of mirrors, and she determined that there were irregularities that prevented the parties from having a fair trial. And among the irregularities, of course, are the last-minute requests to have an expedited trial. So on the Friday before the Monday where LAFCO's action was taken to receive the certified vote results and complete the dissolution. Unless the court has any questions of me, I would go ahead and allow my colleague his turn.
There appear to be no questions. Thank you.
May it please the court, Your Honors, this is Joshua Heinlein appearing on behalf of the county. I don't have any additional points in addition to what Ms. Watley just reiterated. I am here in case your Honors have any questions specific to the county, but otherwise I will submit based on Ms. Watley's arguments.
All right. Does the panel have any questions of Mr. Heinlein?
I have none.
I have no questions.
Thank you. All right, and we'll go back then to Mr. Sherman. You have about 5 minutes left.
Thank you, Your Honor. The first point on the laches, it wasn't unreasonable delay. The case was timely filed. Laches is about 99.9% of the time, and we did brief it in the trial court, applied when a party delays in bringing a case and it's used as an equitable defense to a statute of limitations. The fact that the case was filed and took 9 months or a year in a civil case for which there were discovery disputes, there were ongoing efforts, there was pushback, that's briefed in the trial court, supported by my declaration, supporting facts for that. And Ms. Watley's characterization of at the last minute coming back before, the LAFCO made its decision, our timing availing ourselves before the trial court was based upon the unsuccessful effort in the referendum appeal before this court, which we felt very strongly about, that the decision to rescind was and proceed with dissolution, not rescind, proceed with dissolution of the district was a legislative act. It seemed like it on its face, very credible case, did not come out the way petitioners sought, but obviously put a lot of lock, stock, and barrel in those arguments. This court found it was administrative and LAFCO jurisdiction prevailed. But that's not to say that it wasn't a correct or reasonable belief that would have mooted out the necessity for a trial in the Brown Act case. That's why there was delay. And that was put forward before the trial court, supported by declarations and supported by dates. On early March 9 or 10, when this court issued its ruling in the Southcott case, we proceeded within days to proceed before the trial court because we did know it was imminent. Look, that effort was not successful. That was the reason for holding back and proceeding to trial. And now was the time to bring it before the trial court, which we did. We moved ex parte. We moved ex parte for two reasons. One, because it was now for the forefront and needed to be brought forth, and because LAFCO proceeding their effect with the timeliness issue. And that's when we brought it before the trial court, there was full notice. There was no collusion, did not try to pull a fast one. If you look to the sections in the briefs and supported by the record and the papers presented to the trial, we directly said that the reason for the exigency was the parallel proceeding. And it was briefed, it was in my declaration, it's before this court. So there was no collusion or undue effort or trying to hide anything. But the timeliness makes sense within the context of civil litigation, the proceedings, and the necessity for when it was brought before the trial court. Meanwhile, LAFCO and the county are aware of the proceeding. They had been all along, as I stated before during my argument. They were writing letters to the district. They knew that the board had changed, that there was an admission or change in heart, that they knew there were some undue processes, Brown Act violations. The evidence we present, we're not talking about the merits here on appeal of the Brown Act claim because...
Counsel, excuse me. Let me ask you a question from a very practical standpoint. Let's assume we agree with you that the court erred in granting judgment on the pleadings, and we go back, you go to trial, and you prove your Brown Act violation. Then what happens? We have a public that has said they want a dissolution. So where does this take us? Does it take us to the issue that there was theoretically a violation and therefore attorney's fees are appropriate? Where is this taking us?
I think plenty of precedent, Your Honor, the fact that the voters vote, they enact, government takes an action, and things are rescinded or undone because of some legal undoing. Yes, it would be unfortunate, but isn't that the impetus for this case was based upon, and we've argued in our brief, the fruit of the poisonous tree, where it will undo action by the board, and this would have never happened but for this Brown Act violation. And we think the Brown, in this instance, sits at the top of the hierarchy with regards to this couldn't have occurred.
So as between Brown Act and the public voting, you say basically that the Brown Act has more panache and therefore it wins.
I didn't mean to say it that way. What I meant to say is there wouldn't have been impetus for dissolution if the law was followed because it had failed for 15 years. If there wasn't collusion doing by the board of directors to proceed with this, wouldn't be here but for that. We do believe in that sequence of events, the Brown Act does sit at the top of the hierarchy. With regards to undoing the public process, it's not much different from undoing a referendum at the state level. They have to be constitutional. Sorry, voters, this wasn't going to happen because this is an important law. There's a problem with this in one way or another, and that's the court's province to undo and fix. And we believe that we were timely, we were right, presented it to the court, but for the counties, we argue, battling with the district to get the people on the board, to negotiate the terms in advance, to somehow get that through the jurisdiction. It wouldn't happen but for that, and it does warrant rescission in this case.
All right.
So I'll submit on that, Your Honor.
Thank you very much, Mr. Sherman. Mr. Briggs, do you have any further comments?
I do, Your Honor. Can you tell me how much time I have remaining, please?
You have about 10 minutes.
Okay, thank you. So I want to call the panel's attention to Resolution 2019-02, which was included with my client's motion to dismiss. The panel should keep in mind that we're actually trying to give voter intent on two matters, not just one. The first one was the election of a new governing board in November of 2018. That board took over, was sworn in December of 2019, and they proceeded to change their attorneys. My firm subbed in on March 18th of 2019. If you look at the resolution, you will see that the board wanted to independently cure and correct. It eventually did so, the same time that it was responding to the trial court's original writ to do so. And that's spelled out in the resolution. What LAFCO and the county are doing is trying to rebut what is in the resolution, which was properly evidence, with matters that are subject to judicial notice, which doesn't get to the truth of the items asserted therein. And furthermore, they have to provide admissible evidence to rebut the presumption under Evidence Code Section 664 and the general presumption of compliance with the rules. Furthermore, we have the Brown Act provision that says nothing in this chapter, nothing in the Brown Act prevents a cure and correction. So my client's concern is that we're jumping to the end, which is the subject of the related lawsuit and the related appeal. And in order to jump to the end, we have to misconstrue the Brown Act and misapply rules of judicial notice. And that would be a problem. Justice Haller raises a really good point about, what about this issue of attorney's fees? If there's a dismissal with prejudice, there's no automatic entitlement to attorney's fees. The petitioning parties would have to show that they still meet the requirements for that. And as resolution number 2019-02 indicates, the board wanted to cure this anyways. This wasn't because of a lawsuit, it's because a new board was elected. So if we're going to give meaning to voters' choices, the court needs to give meaning to the voters' choices to replace the old board and put in a new board that wanted to implement a cure and a correction. And then the right place to deal with the consequences of all of that is in the other matter, that we shouldn't distort what the Brown Act says clearly on its face and upend, decades of very clear rules about how we use judicially noticed materials in order to skip steps just to get to the end. I'm happy to answer any other questions, but with that, I'd be happy to submit.
All right. Are there questions from the panel? Apparently not. All right. Thank you, Mr. Briggs. And the case
Thank you, Your Honors.
Case is submitted. We have two cases that follow, Robertson versus Vu